I'm Bob Bork, and on behalf of the 38 members of the Duke lacrosse team and their parents who are filing this lawsuit today, thank you for coming and for your interest. In a moment, Charles Cooper of Cooper & Kirk, who's representing the players and their family members, will speak to you about the filing. He will make a brief statement, 10 minutes or so. He will be followed by Steve Henkelman, who is the father of Erik Henkelman, a member of the 2006 lacrosse team. Both Steve and Erik are plaintiffs in this lawsuit. Steve will make a brief statement. He will not be taking questions. But after he speaks, Mr. Cooper will take your questions. I would also like to note the presence of a number of the players' parents today. They are here to lend their support to their sons as they have throughout this ordeal. They are not going to give interviews, however. And one final comment before we start. None of the 38 players who are filing this lawsuit are here today. They considered participating, but many have jobs, and some are still students and lacrosse team members at Duke. One is an Army Ranger in Ranger School and is preparing to deploy to Iraq. But know this, the players are united behind this lawsuit. At the same time, they are understandably concerned about retribution and negative, maybe even slanderous media coverage. Who can blame them after what they endured for 13 months in 2006 and 2007? They are walking a fine line between trying to live normal lives in the wake of an unspeakable trauma, and at the same time trying to get answers to questions that remain unaddressed by the university. They need to have peace to heal, but there can be no healing without accountability. With that, let me give you Chuck Cooper.
Thank you very much, Bob, and good afternoon, ladies and gentlemen. I, too, thank you very much for coming this afternoon. My name is Charles Cooper with the Washington law firm of Cooper & Kirk. Our purpose today is to announce the lawsuit that I and my colleagues are filing on behalf of 38 members of the 2006 Duke lacrosse team and certain of their parents. First thing I want to do is introduce my colleague, David Thompson, also of Cooper & Kirk. Also want to take note that our member of our firm in our North Carolina office is Nicole Moss, and will be assisted in this matter as well by the Durham law firm of Thomas, Ferguson, and Mullins, and Bill Thomas of that firm. The players and their parents are acutely aware of the extraordinary nature, indeed the historic nature, of today's action. We're aware of no other instance in which essentially an entire team of student athletes has been so aggrieved and injured by their university's collective mistreatment and misconduct that they have united together in a lawsuit seeking to call the university and its officials to account for their actions. I want to emphasize, before turning to a brief outline of the complaint, that the players and their families take this historic action with great reluctance, and only after reaching out to Duke and its leadership in an effort to get them to self-examine their roles and actions in this tragic episode in the school's great history, to bring forward the full truth of those roles and actions, and to make amends for their mistakes and their wrongs. That effort did not succeed. But they remain united in their determination to insist on the full truth and on an accountability from Duke. The players and their families also bring this action with great apprehension and some measure of trepidation. This lawsuit is born out of Duke's and Durham's sustained wrongdoing and callous conduct against the players over many months in 2006 and 2007. And the players and their families are painfully aware of what Duke's leadership is capable of doing, and they are understandably apprehensive that today's action will bring more of the same down upon them. But again, they remain united in their determination to insist upon the full truth and accountability from Duke. Finally, the players and their families bring this action with great sorrow. Many of these families have deep and abiding multi-generational ties to Duke University. Ties that are deeper and longer lasting than many of those currently in Duke's leadership. They love it dearly. These plaintiffs are the institution's students, their alumni, its supporters, and its future alumni and supporters. Duke belongs to them just as much as it belongs to Duke's current leadership. The players and the parents do not welcome or relish the action that they take today. But again, they are united in their determination to insist on the full truth and accountability from Duke. The tragic tale that gives rise to the plaintiff's claims is known now to almost everyone in the United States and to millions more throughout the world. For these Duke students were for 13 months reviled almost daily in the local and national press as a depraved gang of privileged white hooligans who had hired a black exotic dancer to perform at a team party, had brutally gang raped and sodomized her in a crowded bathroom, and had joined together in a wall of silence to hide the truth of their heinous crimes. But it was all a vile and a shameful lie, and it caused the plaintiffs tremendous suffering and grievous lasting injuries. The individual defendants in this suit are chiefly, one, Durham officials who corruptly seized upon and exploited the accuser's lie and the intense media firestorm that it generated to advance their own career ambitions, to further their own ideological agendas, or to gratify their own personal prejudices. And secondly, Duke officials who possessed convincing evidence of the players' innocence and who had a responsibility to their students to speak out, but who not only steadfastly remained silent, but also lent Duke's credibility to the rape allegations by capitulating to an angry mob's demands to condemn and punish the innocent players and their blameless coach. Chief among the wrongdoers in this case, of course, is former District Attorney Michael Nifong, and as everyone now knows, he and his equally corrupt police investigators concealed exculpatory evidence, manufactured inculpatory evidence, rigged photo lineups, tampered with and intimidated witnesses, and blatantly lied to the court and to the public in a determined effort to indict, try, convict, and ultimately to imprison 3 lacrosse players. Any 3 would do, for a crime that the prosecutor and investigators knew had never happened. Because of federal bankruptcy laws, Nifong cannot be named individually as a defendant, but his wrongful actions were taken on behalf of and are attributable to the City of Durham. Less well known is Duke Hospital nurse Tara Levesey, who played a pivotal role in causing and enabling Nifong's corrupt rape investigation. Nurse Levesey was the inexperienced sexual assault nurse who assisted in the forensic medical examination of the accuser, Crystal Mangum, a few hours after the fictitious rape was alleged to have occurred. As North Carolina Attorney General Roy Cooper stated after his independent investigation had established the player's innocence, there was no medical evidence supporting Mangum's claim of sexual assault. Yet Nurse Levesey assured Nifong's investigators on March 16th, 2 days after the alleged rape, and at various points throughout the corrupt investigation, that Duke Hospital's forensic examination had yielded evidence of blunt force trauma and other signs consistent, as she said, with sexual assault. Her statements flatly misrepresented the medical evidence from that examination, and it breathed life-giving credibility into rape allegations that were so openly contradictory. You'll recall that the accuser had variously claimed and recanted being raped by 1, 3, 5, and 20 players. allegations that were so contradictory that Duke and Durham police had initially dismissed them as a transparent hoax. Finally, Duke University's official statements, actions and inactions in response to the rape hoax crisis were tightly managed and controlled by President Richard Broadhead, with the active oversight of Robert Steele, chairman of the Duke Board of Trustees. As Steele acknowledged months after Nifong's corruption had been publicly exposed, Broadhead, and these are Steele's words, had consulted regularly with the trustees, and anyone critical of President Broadhead should be similarly critical of the entire board. The accusers' explosive allegations had created an angry mob, led primarily by active Duke faculty members and student protesters, as well as many hostile elements in the media. And that mob immediately rushed to condemn the lacrosse players, to intimidate and denounce the team's defenders, and to demand the team's swift and severe punishment. Broadhead repeatedly succumbed to the mob's intimidation and demands, and he effectively condoned its actions. Broadhead and Duke actively suppressed exculpatory evidence, discredited exculpatory evidence that was publicly disclosed by others, and repeatedly, consistently refused even to review exculpatory evidence compiled by the plaintiff's defense lawyers. Let me share a few specific examples. When Nifong and news reports asserted as a fact that accuser Crystal Mangum had been raped and sodomized by 3 Duke lacrosse players, Broadhead and Duke withheld the report of their own police officer that Mangum's story was wildly inconsistent from the beginning. And when the officer's report was publicly disclosed, Duke took steps to discredit it. When Nurse Levesey told investigators that the medical and physical evidence supported the rape allegations, Broadhead and Duke failed to disclose that the forensic exam had shown no such thing. When Nifong publicly speculated that condom use might explain the negative DNA test results for all 46 white team members, Broadhead and Duke failed to disclose that Mangum had told doctors and nurses at Duke hospitals 3 times that her attackers, her fictitious attackers, had not used condoms. When Nifong repeatedly charged that the lacrosse players were hiding behind a conspiratorial wall of silence, Broadhead and Duke failed to disclose that the team's co-captains had voluntarily assisted police in searching the residence where the party had taken place, had voluntarily submitted to an all-night interrogation, had voluntarily provided DNA samples, and had volunteered to take lie detector tests, which were declined. To the contrary, Broadhead actually reinforced the wall of silence lie by repeatedly urging the players to cooperate with the police, knowing full well that they had done just that throughout the investigation. Months after the rape allegations and Nifong's investigation had been exposed as a malicious and tragic hoax, Broadhead attempted to defend his refusal to speak out, even as it became increasingly clear to everyone that the Duke students were the victims of a malicious hoax. He did not want to risk creating the perception, he said, these are his words, that a well-connected institution was improperly attempting to influence the judicial process. And so Broadhead and Duke remained silent and passively looked on while a politically ambitious and plainly unethical prosecutor, abetted by a mob led by activist Duke professors and student protesters, put 47 innocent Duke students through what Broad himself later admitted was an ordeal the likes of which few have known. The only wall of silence erected in this tragedy was Broadhead's. Broadhead also looked on passively as activist members of the Duke faculty and student protesters waged an extraordinary public campaign of abuse and harassment against the innocent lacrosse players. Broadhead took no steps to enforce Duke's plainly applicable anti-harassment policy, nor did he criticize, let alone discipline, the activist professors and student protesters, nor did he even disassociate the university from their shameful actions and statements. And I'm sure all of you will recall the pot-banging protests, the castrate banners, the wanted posters, the student protests and marches. Indeed, months after the rape hoax had been publicly exposed, Broadhead conceded that activist faculty members and student protesters, again, his words, were quick to speak as if the rape charges were true, and that the public, as well as the accused students and their families, could have thought that those expressions of the universe were those of the university as a whole. Indeed, how could they think otherwise? Finally, Broadhead issued a series of carefully timed public statements and imposed a series of increasingly severe disciplinary measures on the team, including ultimately the cancellation of the season and the firing of the coach, all in an effort to satisfy the mob's demands for immediate and severe sanctions against the team and to distance Duke and its administrators from the intense public hostility that had been focused on the innocent lacrosse players. The inevitable effect of Broadhead's statements and actions was to impute guilt to the players and to further inflame public opinion against them. So as a direct and foreseeable result of Duke's and Durham's actions, the lacrosse players and their families have suffered serious deprivation of their rights and interests under North Carolina law and federal law, including the United States Constitution. And they have suffered a variety of injuries and damages, the most grievous of which, however, is to their reputations and the severe emotional anguish that 13-month period visited upon them. Again, Broadhead himself conceded to a lacrosse player after it became clear that the whole sordid tragedy was a hoax. The members of the Duke's men's lacrosse team have lived through an ordeal the likes of which few have known. There is no undoing the agonies of the last months. Well, that is true. There is no undoing those agonies. But again, the players and their families are united in their determination to insist on the full truth and accountability from Duke and from the City of Durham. Steve?
Good afternoon. My name is Steve Henkelman, and I'm from Swarthmore, Pennsylvania, which is just outside of Philadelphia. More importantly, I'm the father of Erik Henkelman, who is a graduate of the Pratt School of Engineering at Duke and was a member of the 2006 Duke men's lacrosse team. My purpose in speaking to you today is both to explain why Erik and I have decided to add our names to this lawsuit, and to the extent at all possible to describe the intense fear and anxiety that overwhelmed every parent of every player on that team for so many months. For us, it was a senior year. Graduation was only a couple of months away. And for the senior players, it was one more chance for a run at the national championship. But almost overnight, all of our optimism was shattered, replaced with gut-wrenching fear of a totally unforeseen, unimaginable new future for Erik. Unfounded accusations of rape and kidnapping were being hurled at almost every player on the team. Erik's bright future of just a couple days before had turned into a dark possibility of 30 years in a North Carolina prison for something that had never happened. But surely the legal system would work. Surely in the face of such serious false allegations, Duke University would stand up for Erik and for his teammates. They were their students. They were the players Duke had pledged to support. But the legal system wasn't working. And Duke, rather than providing that so needed support, coldly turned away and abandoned these young men and their families. Some Duke professors, hired to be teachers and mentors to our sons, turned to openly harassing lacrosse players in class. Others encouraged faculty members and students to hold demonstrations to condemn our sons, calling them publicly racists and rapists. How could the Duke administration allow this abuse to occur? How could they allow it to continue? How could Richard Broadhead, as president of Duke, refuse to show even the most basic courtesy and meet with the lacrosse parents gathered in Durham on March 25th, the day he had orchestrated the abrupt cancellation of the Georgetown game while the players were on the field? The day he would issue his first guilt-implying press release featuring his, and I quote, "sexual assault will not be tolerated at Duke" headline. It quickly became obvious to me and all the other parents, Duke was in a damage control mode. They were willing to sacrifice a few, our sons, for the good of the institution. There was to be no support from Richard Broadhead, Robert Steele, or any Duke administrator for our sons. The condemnations were everywhere, on campus, in the national media, on every channel, every news channel, every night, on the front page of our local paper, the Philadelphia Inquirer, with pictures of my son Erik and Tony McDevitt, players from the area on the team, all swayed by Duke's public implications and Nifong's pronouncements of the players' guilt. Even some of our closest friends began to be convinced that something must have happened. Our phone rang incessantly. Requests for interviews would not stop. Media trucks showed up on our street. Reporters queried our neighbors, what kind of a kid was Erik? What kind of a family were we? Threatening protests led by Duke faculty and students, wanted posters strewn across the campus, lie-filled Crime Stopper flyers produced and distributed by the Durham police around the neighborhood forced my son Erik and his roommates, two of whom were his lacrosse teammates, to leave his house out of fear and find another safe refuge. As a parent, I was in continual fear for his safety as the threats continued and were well published. The abuse was relentless. Each day I wondered, what would Nifong claim next to further his fraudulent case? What evidence might the police fabricate or conceal? As a parent, for months, no hour went by free of this intense anxiety. At night, sleep was intermittent, interrupted repeatedly by the fear of Erik's name being randomly chosen as one of the three, or of Nifong fulfilling his threat to indict everyone who was at that party. Frankly, Erik maintained more confidence in the power of the truth than I was able to. He stayed in Durham in spite of the hostile atmosphere. For a while, even holding out hope that President Broadhead would honor his commitment to lift the suspension of the season when evidence of innocence was forthcoming. The results of that DNA testing couldn't come soon enough for us. They would, as promised in the official court documents, clear the innocent. They would clear our sons. To get by, the players were relying upon the support of each other, of their families, and some of their fellow students who knew them and believed in their innocence, and one lone but wonderful voice on Duke's payroll. But on April 5th, while I was in Los Angeles, Erik called me, and his voice told the story even without the words. He was devastated. Without any evidence upon which to base his actions, without waiting for the DNA results which Nifong withheld, President Broadhead had just forced Coach Pressler to resign and had just officially terminated the season. And the chairman of the board, Bob Steele, his justification, we just had to stop those pictures of the team practicing. For Erik and the other seniors, the end of Duke lacrosse had come. And of much greater concern to me was the immediate realization that Broadhead's action had just driven a huge nail into the player's coffin. That day, 3,000 miles separated me from being able to give my son a hug of support that we both needed. Everything was falling apart. How could Broadhead steadfastly refuse to even look at the mountain of evidence which showed that the rape charge was a lie? Who would step in and stop Nifong and Gottlieb and the others from their perverse pursuit of convictions for something that had never happened? It became alarmingly obvious. No one was going to step in. We were totally alone. But ironically, in the end, it was the severity of Nifong's own egregious conduct that exposed the truth that for such a long time so many had tried to cloak in lies. So why, with this outcome, should we bring this lawsuit today? Because no one in Duke's leadership has been willing to accept the real responsibility for their wrongful conduct. Because no one in Duke's leadership has taken any action against those at Duke who violated the university's own policies specifically designed to prevent the type of abuse and harassment inflicted on our sons. Because no one in Duke's leadership has had the integrity to look these young men and their parents in the eye and personally apologize. And because no one in the city agencies of Durham has acknowledged their responsibility for their inexcusable efforts to circumvent justice. Only with this lawsuit may it be possible for the full truth to come out, to hold Duke's leadership accountable, to help further the restoration of our sons' damaged reputations, and to hopefully make it less likely that other parents and their sons or daughters at Duke or any other school will have to go through something like this again. Thank you.
Let me just say that we will have the complaint when it's filed. I believe it's in the process of being filed. It'll be available at dukelawsuit.com. Some of you have asked me to email it individually. I can do that. Also, just send me an email and I'll reply with it when I have it. Now we'll take questions for Chuck, and we'll start with a few, 2 or 3 here in the room, and then there are some reporters on the phone, and I will go to the phone after a couple of phone calls.
One name clearly missing from the lawsuit. Sorry, right for the microphone. My name's Dan Bones from WRL TV in Raleigh. One name clearly missing from the lawsuit is Mike Nifong, and I know you mentioned that he's in the middle of his bankruptcy hearing. Depending on the outcome of that hearing, is it possible that there is a time when his name could be added to this lawsuit?
His name in the drafting of the suit was definitely in it as a defendant, and it was only because of his bankruptcy filing that he was deleted. If it comes to pass that he will no longer be protected by federal bankruptcy law from the lawsuit, we will add him as a defendant. Yes, back there. Yes, ma'am.
Hi, Rebecca Hall, WTVD in Raleigh. We just got a response from Duke University, and I just want to read a little bit of what they said. It says, "We have not yet seen a lawsuit, but if these plaintiffs have a complaint, it is with Mr. Nifong. Their legal strategy attacking Duke is misdirected and without merit." How do you respond to that?
I think, I honestly think that my entire statement responds to that. And it is of a piece with Duke's conduct from the day these allegations became public.
Let's go to the phone.
We have Rick Bond up here. Please go ahead.
Go ahead, please.
Hello, I don't think we heard the question. Can you repeat that, please?
Coming from the line open, please go ahead.
All right, we go to the next call. There's another call. All right, back in the room. Sir, over there.
This whole scandal is rooted in a party that did include illicit behavior, including underage drinking and the hiring of 2 strippers. By filing this lawsuit, are you guys prepared for a re-examination of that night and all the behaviors of the people involved in that party?
It is true that the party that took place involved exotic dancers and involved as well underage drinking. The players were punished for that severely. They were punished for that long before the team's season was canceled and their coach was fired. That punishment was for a rape that didn't happen. And that's the important thing to keep in mind. This isn't about college drinking, a unfortunate phenomenon that takes place at college campuses all over the country. This is about a vile lie and a hoax that caused unspeakable suffering to these players. The players, I want to remind you, early on expressed their shame and their regret and their apology for the party and for the things that they were ashamed of about that party.
I guess right up here.
Hi, this is Penny Starr with CNSnews.com. I'm wondering why the woman who falsely accused them is not in the lawsuit.
The lawsuit really actually tries to explain that. The accuser, it is clear, and for all that is now known about her, is a very deeply mentally disturbed young woman with drug dependence. It appears that her initial claim of rape, which then kind of snowballed out of control, was uttered in apparent concern that if she was taken in for drug rehabilitation or mental observation, she would lose custody of her children, at least for a time. Those elements of the background of this have been published, and it's for those reasons we see no reason to bring her into this action.
Sure.
Jeff Barker with the Baltimore Sun. I wonder what Duke might have done to head off this lawsuit. You mentioned there were talks with Duke and the parents.
Well, again, I tried to outline the efforts that have been made, and there have been certainly discussions between these parties. They did not succeed. Discussions of that kind are confidential, and so I'm not really able to get into details about them. But it has been the effort of the players and their parents, and as well, and this is true before and after they have engaged counsel in this matter, to reach out and to resolve this to everyone's satisfaction, short of this action that wasn't able to be done.
Barb Barrett with the News and Observer in Raleigh. Didn't Duke offer to pay the legal fees of these families, and why wasn't that accepted?
Again, I'm not going to get into specifics about the dialogue that took place both before and after I and my colleagues got into the case. I am only going to say that compensating the parents for their out-of-pocket expenses for this ordeal would not be an adequate response to the situation.
Here behind them.
It says here that 11 of the members, I'm sorry, Lila Meredith with Associated Press Television. It says here that 11 of the members are the class of 2008 and 9 are the class of 2009. Are any of these players still in attendance at Duke? And if so, how is that going to affect the case?
Yes, there are, and there are, I think, 20 players who remain at Duke, remain on the team, who are part of this action. And it was with them certainly in mind, as well as the other plaintiffs, that I mentioned the apprehension, the trepidation that the players and their families have in coming forward today with this action. We hope that their lives at Duke and beyond can go forward now at Duke, and their relationship with their teachers, their fellow students, the Duke administration will not be affected by today's action. Yes.
What do you say to critics who believe that 3 pending lawsuits is too much and may actually be counterproductive?
Well, I'm not sure I understand the nature of that criticism. There are 3 pending lawsuits. The indicted players who had previously been able to resolve their differences with Duke, and for that reason have never filed a lawsuit against Duke, have filed a lawsuit against Durham and its various officials, NIFONG and others, although I should mention that because of the bankruptcy law, NIFONG has been dismissed, as I understand it, from those suits, as he must be. 3 other players have previously filed a lawsuit against, apart from the indicted players, 3 other unindicted victims of the investigation and the hoax have filed a lawsuit against Duke and Durham, and now 38 players have. All of these cases are going to be put together in the same courtroom. We are filing our suit in the same courtroom. They will proceed in a, I'm sure, a coordinated, if not consolidated fashion. And so it will be important for, I think, this matter to be pulled together in that fashion and fully resolved once and for all.
Give a call from the telephone.
I have a question from Ann Weiss, that server. Please go ahead. Ms. Weiss, line is open. Please go ahead with your question.
Okay, well, back in the room.
appear to be having some technical difficulties, and I apologize for that from the reporters and other media people who are with us only by phone.
I'm wondering why all the parents aren't plaintiffs in the case. Why only a few parents joined in this case?
The factors that go into making that kind of a decision are varied and personal, and they're going to remain private to the individuals who have made their decisions.
There was one as well. There was one African-American player who was cleared of all wrongdoings right away. His name is included in this lawsuit. If he was cleared, why is he included in the lawsuit?
The specific elements of his claim are going to be developed in the court, as well as all these other claims. But yes, he is a part of this lawsuit. Absolutely.
There's lots of talk in the lawsuit about the conduct of professors, including some of those who actually wrote an ad in the school paper and who participated in some of these demonstrations. Why are they not named in this lawsuit?
That too, that issue gets into litigation strategy questions that I'm just not going to respond to. I think the important thing is that their actions were effectively condoned by Duke and its leadership, and which made Duke responsible for them. So Duke is a defendant in the case, and it'll be to Duke that we look for accountability for the conduct of the various faculty members.
This question would be for Mr. Cooper or for Mr. Henkelman. I'm curious about how you think Duke could or should have responded to the allegations in the spring of '06.
I'm sorry, did you say that is for Mr. Henkelman?
I would appreciate if you both could answer.
Yeah, actually, I am not going to open the media inquiries in the press to the various parents, including Mr. Henkelman. There were the Duke leadership should have simply inquired into the information they had. They should have been open to accepting and verifying the emphatic claims of innocence by their players. They should have done the opposite of everything that I've just outlined in my statement. They, as Mr. Henkelman did say, that they simply turned their backs on these students.
Right here.
On May 15th of 2006, almost 2 years ago, Nifong issued a release saying that it was just as important to remove the cloud of suspicion from members of the Duke University lacrosse team when he indicted the last person. That was almost 2 years ago. That was the date at which he said everyone else is innocent. These families have been cleared since then. Explain to us in more detail why you're coming after this 2 years later, and what exactly is the harm that's been done to the players? Can you give us more specifics about the actual harm that you guys are citing here?
The course of events that have taken place over that 2 years is I think, pretty well known. As I mentioned earlier, the players and their parents have made every effort to resolve these concerns with Duke itself, And it is only with great reluctance that here, yes, 2 years later, they have concluded that there is no course other than this one available to them to determine the full truth and to hold Duke accountable for its conduct with respect to the lacrosse members, team members, and their families. I outlined the harms that, and I think Mr. Henkelman spoke poignantly to the harms that the players and their parents have endured. The complaint details them in additional detail, and I am satisfied with the force of those comments.
Sorry, I hadn't identified myself prior. My name is Sergio Quintana. I'm a reporter with WNCN TV in Raleigh. Having covered some of those demonstrations as described as mobs in this lawsuit, a lot of the people were responding to prior behaviors of the members of the Duke lacrosse team within the community. So their concerns were not in a vacuum as some people have described. And I'm wondering, by filing this lawsuit, is there any response to members of the community in Durham who still feel like that, and how this lawsuit could affect that as it continues?
This lawsuit is about the misconduct focused on and directed at the lacrosse players and their families. That's all it's about.
Hi, I have a follow-up to my previous question, and my name is Sarah Lipka. I'm with the Chronicle of Higher Education. You had answered my previous question by saying that Duke should have inquired into the information it had and verified the claims of innocence by their players. I wonder what right and responsibility you think a university has to investigate a criminal case involving its students at the same time as, or perhaps counter to, a state investigation?
The legal background with respect to these claims is laid out in the complaint, and I'm going to leave the legal analysis to the complaint and to the court proceedings that are before us.
One more?
Yeah.
Okay, one more? Erik? Oh, sorry, back there.
It says here 38 of the 47 members of the team. Obviously, the 3 others, their cases have already been handled. Did you have conversations with those who chose not to join this lawsuit, and did they give reasons why they did not feel the need or comfortable to doing this?
As I said earlier, with respect to individual decisions, either to join or not to join this lawsuit, well, at least with respect to why individuals have not joined this lawsuit, those are personal and private, and to whatever extent I may know them, and I don't know all of them, or with respect to all of the players who have not decided to file, they're going to remain private and personal.
Okay, I guess that's it. Thank you all for coming. Again, as soon as the complaint is filed and I have a copy of it, I will put it up on dukelawsuit.com. And if you have any questions, you can reach me through dukelawsuit@gmail.com. And I think my phone number is also on the press release. So thanks very much.